Let's talk about alternative dispute resolution. California has more dispute resolution activity than almost any other state in the country, other than New York, Washington, D.C., and Massachusetts. This includes written state complaints that are filed with the California Department of Education, mediation requests, and due process complaints that are filed here in California. The Center for Appropriate Dispute Resolution in Special Education issued a report showing some trends about dispute resolution in special education matters. National data trends in dispute resolution shows over the past 11 years increases in the formal dispute mechanisms of due process complaints, with the highest increases during the past 2 years of the pandemic. Written state complaints have remained relatively steady over the same period. But there has been a significant decline in mediation requests during the pandemic after years of growth. The rise of virtual dispute resolution options, particularly for less adversarial options, such as facilitated IEP team meetings and mediation, is a promising byproduct of the circumstances posed by the pandemic. The average agreement rates for resolution meetings and mediations have trended downward in the last 3 years. Special education dispute resolution activity occurs more frequently in high-income local educational agencies than in low-income local educational agencies. Also, local educational agencies with predominantly Black and Hispanic students are less likely to have dispute resolution activity than local educational agencies with fewer minority students. So, what percentage of all California due process cases do you think are filed by parents or students? Is it 26%, 51%, 68%, or 89% of all of the cases? The answer is D, 89%. Here's a chart showing all of the cases filed by both school districts or charter schools that are their own LEA for special education, and cases that are filed on behalf of the students. And as you can see, an overwhelming amount of the cases that are filed on behalf of students. There are really 3 reasons for conflicts that arise in special education. One is at the very beginning stages in the design and development of the IEP. When parents and schools don't necessarily have the same access to the same information about the student, or they have different understanding or ideas about the student's strengths and needs, this could result in conflict in special education. And this is natural given that parents see students in a different environment in the home than schools will see students in the school environment. The second reason for conflict in special education is implementation of a special education program. So oftentimes parents may perceive that plans that had been agreed to for a student special education program are not being adequately implemented, or they're not being implemented as they thought that everybody had agreed to. The third area where there may be conflict in special education is just the relationship between the school and the family. People have different styles of interaction. There could be breakdowns in communication and or a loss of trust. Oftentimes, by the time a lawsuit occurs, the details of the dispute are less important than just the animosity that has built up between the two parties. Most special education disputes have elements of all 3 of these different areas of conflict. And so this requires methods of resolution that address the unique character of the conflict as early as possible in the dispute. So, what is alternative dispute resolution? Alternative dispute resolution, or ADR, is an umbrella term referring to any resolution process that's agreed to by disagreeing parties in which the services of a neutral professional are used to assist them in reaching an agreement and avoiding litigation. There are a number of advantages to using an alternative dispute resolution process. First, there are much faster and more cost-effective resolutions than proceeding to more formal litigation. Sometimes it can take months and months to go through a due process hearing and receive a decision. And if those decisions are appealed to court and through the appeal process, it could take several years to get a resolution. Also, an advantage of alternative dispute resolution is relationship building. Oftentimes, when a school and a parent go through a due process hearing, it's very difficult to rebuild that relationship. And unlike other types of disputes, maybe in civil litigation, where the parties may go to trial and then never have to see each other again, for some cases, students and schools have to continue to work together through the IEP process as long as that student remains living in that district or enrolled in that school. They have to continue to work together up until the student graduates or perhaps even until they turn age 22. The other advantage about alternative dispute resolution is that you can receive very customized and satisfying resolutions. And so, along with that, is just the flexibility that parties have in alternative dispute resolution. Whereas when you're in a hearing, you're really constrained, that the hearing officer is constrained by the four corners of the law and what's required to be provided and what the cases say are a free, appropriate public education. Whereas you have the opportunity to be much more creative and flexible and thinking outside the box to arrive at solutions that both parties can be satisfied with. They may not get everything that they want, either side, but through compromise, both parties can believe that they can move forward. Also, durability of the agreements through alternative dispute resolution can be much more advantageous. Oftentimes, when you go through the hearing, neither party is completely satisfied with the outcome of the decision. And so, the agreements, in terms of the durability of the agreements reached in alternative dispute resolution, are much more likely to stick when everybody has bought into them. There are some limitations to reaching agreements through alternative dispute resolution. One may be the need for legal representation. More and more often, cases that get filed by parents or schools, there are attorneys that are involved, and the process has become much more legalistic, and the settlement agreements have become much more formalized and detailed, that parties may feel like they need legal representation in order to navigate that process. Also, that there is a recognized power imbalance between the educators, who often have the credentials and experience in terms of education, and what various data means, and they have access to information, whereas parents may not have that same level of education or experience in terms of education appropriateness. Also, alternative dispute resolution often really heavily relies on an outside third party, and the competence of that third party in helping the parties reach a resolution is another unknown factor. Sometimes alternative dispute resolution can be less formal, particularly when you don't have attorneys involved, which could create problems down the road if it's not clear what the parties have agreed to. So there's multiple opportunities for alternative dispute resolution in special education disputes, and we're going to talk about each one of these. One is IEP facilitation. Two is informal alternative dispute resolution. Three is something called mediation only. And four is mediation that's done in conjunction with a due process hearing. So let's first talk about IEP facilitation. IEP teams may find it beneficial to be guided through the IEP development process by an individual with meeting management and facilitation skills. When IEP teams have reached an impasse, or they might feel that meetings are going to be contentious, it can be helpful to have an independent trained facilitator help guide the process. Some surveys have shown that both parents and schools feel like communication really happens very uniquely for the first time when they've hired an outside facilitator to help focus the parties on the communication. While considerable variability exists related to this practice and in those who serve as facilitators, both the California Department of Education and local educational agencies are increasingly turning to this approach. So, what is the job of the facilitator at an IEP meeting? The facilitator's job is to keep members of the team focused on the development of the IEP while addressing conflicts and disagreements that may have occurred before or during the meeting. Such assistance coming from an individual who is not a member of the IEP team or in any way supposed to be making decisions about what's appropriate for the student, they can help encourage cooperation among the team members. They can help team members feel heard, and they can help the IEP development process or the meeting be more successful when their sole job is just to focus on communication. Some of the benefits of IEP facilitation is that it's a collaborative process that emphasizes shared responsibility for the development of an appropriate IEP for the student. Facilitation can result in a decrease in more formal procedures, such as due process hearings and mediation, more durable IEPs that are going to stick and because everybody has really felt heard and that their input has been valued, improved relationships between schools and families, improved communication skills, resolutions to disputes that are more mutually satisfying to both families and schools, and greater capacity of teams as they learn from facilitators how to conduct meetings successfully. This has been a unique advantage, I think, to IEP facilitation, is that when you see someone who's a professional and you see how it's done, those folks can take those skills and make IEP meetings be much more smooth down the road. Another opportunity for alternative dispute resolution is sort of an intermediary step between IEP facilitation and a more formal mediation process, often called an informal or proactive alternative dispute resolution. Oftentimes, this is someone who is a trained administrator, maybe through a local educational agency or through a SELPA, that has been trained on mediation techniques and how to bring parties together to find a mutually agreeable solution. These alternative dispute resolution meetings could be virtual or in person. They're a highly flexible way to resolve disagreements. Again, they're more timely and less costly than a mediation or a hearing. The parties control the outcome to any settlement agreement. And again, it's an opportunity to preserve relationships between parents and schools. Then there's the opportunity for what's called a mediation only through the Office of Administrative Hearings. The reason it's called mediation only is because there's also a process that we'll talk about where there is an opportunity for mediation when a party files a due process hearing request. But this is where the parties are just interested in participating in mediation. It's a voluntary dispute resolution process where a neutral mediator from the state's Office of Administrative Hearings assists the parent and the LEA in discussing and attempting to resolve a disagreement. There's no cost to either party to participate in this process. It's totally voluntary, so both parties have to be willing to participate in this process. And the mediators are selected by the state, and they know the laws that relate to special education. If a mediator from the Office of Administrative Hearings serves as your mediator in a mediation only, they would not be the same administrative law judge that would ultimately hear a due process hearing if eventually a due process hearing request were to be filed. Generally speaking, attorneys are not allowed to participate in a mediation only, although the Office of Administrative Hearings has granted requests by schools and parents who have allowed, who both are willing to allow the attorneys to participate in a mediation only. That's a totally free service that's offered by the state of California. It's confidential also. So this means that nothing that's said during that mediation could be used against either party at the hearing. So this allows the parties to be much more candid with each other in discussing the issues at hand to not fear that something's going to be used against them later on in a hearing. Again, this could be held through Zoom on a mutually agreeable date. It's usually relatively quick. It's held typically within about 15 days of filing a request for mediation only. Also, if any party needs an interpreter, the Office of Administrative Hearings will provide an interpreter at no cost to either party. Ultimately, if the mediation only process does not resolve the disagreement, either the school or the parent may initiate a due process hearing in order to resolve the dispute. Either the parent or an LEA may file a request for a mediation only. The forms are available on the Office of Administrative Hearings website, and there's a link here in the materials for the forms. There's different forms, one for a parent to use and one for a local educational agency to use. Once those forms are completed, the form must be uploaded through the Office of Administrative Hearings secure e-file transfer system, and a copy must be sent to the other party. Here is information on how to upload the request for mediation only to OAH's system, and that's the link here at the bottom of the slide. And as I mentioned before, mediation in conjunction with a due process hearing is also an opportunity for alternative dispute resolution. This is the most common type of due process request. When a complaint is filed starting a mediation and hearing case, the Office of Administrative Hearings will send a scheduling order to the parties that lists dates that they have scheduled for a pre-hearing conference and a due process hearing. The scheduling order doesn't automatically set a date for mediation, but it does set a deadline for requesting mediation. So if the parties are interested in participating in mediation before the hearing dates occur, the parties have to get together and agree to a mediation date and then submit a request for mediation to the Office of Administrative Hearings. There is an optional form that's provided by the Office of Administrative Hearings in order to request a mediation. Sometimes along with that request, you may be interested in trying to continue the hearing dates or push the hearing dates out a little bit to allow the parties an opportunity to conduct a mediation. That request for hearing must be filed with the a request for mediation must be filed with the Office of Administrative Hearings no later than 3 business days before the date of the pre-hearing conference that's listed on that scheduling order. If the parents or students are not represented by an attorney, the Office of Administrative Hearings will provide staff to contact the parents within 7 days after the scheduling order has been sent to offer assistance in calendaring a mediation date. If the parties reach an agreement at mediation, then the case will be closed. If the parties either do not elect to have a mediation, or they do have a mediation but they don't reach an agreement at mediation, then the Office of Administrative Hearings will move forward with holding the pre-hearing conference where the assigned administrative law judge will discuss the case with the parties, clarify the unresolved issues, and confirm the dates of the hearing. This is also the time when the administrative law judge will go through all of the logistics for the hearing related to witnesses and exhibits. So what exactly happens at these mediations? So there's both a full day option, usually scheduled from about 9 a.m. to 4:30 in the afternoon, or half day options are available. Usually the people that attend mediation would be the parents, a representative of the local educational agency who has authority to actually settle the case, and some knowledge of the case. And sometimes that's not the same person. So sometimes you may have, for example, a director of special education, and maybe you have a program specialist or the case manager who's most knowledgeable about the case. And then there's the mediator. Again, attorneys generally may not attend when it's a mediation only, but attorneys may attend when it's a mediation request that's been filed in conjunction with a due process hearing request. Mediators typically have 2 different kinds of approaches to mediation. One is more of a facilitative approach, and one is more evaluative. The facilitative approach seems to be the most common approach that most mediators use through the Office of Administrative Hearings, where it's their role to really just facilitate communication between the parties. They aren't necessarily there to make findings of facts or conclusions of law and decide who's right or who's wrong. Some mediators may take a little bit more of an evaluative approach, and they put their judges' hats on and they kind of guide the parties in saying, well, if I were hearing this case, these are the things that I would be looking at. And it is a little bit more of an aggressive approach to mediation. The mediation typically involves what's called the caucus process. And so while you may all start out in the Zoom session in mediation in the same room on the screen all together, and you may have a little bit of information back and forth, at some point the mediator will break you up into two groups, which is called the caucus process. It's during those caucus sessions where the parent will have an opportunity to speak privately with the mediator and will also have an opportunity to consult with their attorney if they have one. And same with the school. The school side will be in a separate room from the parent, have an opportunity to discuss the case privately with the mediator and to consult with their attorney on any of the issues. And then the mediator spends most of the day going back and forth between the two parties' rooms and delivering information, asking questions, and sharing proposals with one another about how they may be able to resolve the case. The nice thing about the mediation is that everyone is involved in the decision making. Again, no one is forcing anybody to be there, that everybody at mediation really has a strong desire to try to resolve the case. Usually in a settlement agreement, there will be a confidentiality clause that is often important to both sides, that nobody necessarily wants what happens at mediation to leave that room. And so the parties will typically agree in a settlement agreement to make sure that nothing in the settlement agreement would be disclosed to outside parties, unless it's absolutely required in order to implement the terms of that settlement agreement. So ultimately, if it's a successful mediation, it will typically result in a settlement agreement where the parties reduce all of their agreements to writing and it becomes a legally binding document. When all parties sign the settlement agreement, it becomes a binding contract. But the Office of Administrative Hearings doesn't necessarily have jurisdiction to enforce a settlement agreement between a parent and a school. Parents can seek assistance from the California Department of Education to help them enforce an agreement if it's not being honored by the school. Parents can also choose to go to state or federal court to ask a judge to enforce the agreement. Occasionally, a failure to do what was agreed to is considered a denial of FAPE for a student and can form the basis of a new complaint with the Office of Administrative Hearings. So, of all of those cases that get filed in the California Office of Administrative Hearings, about 97% of the cases end up getting resolved without going all the way to a hearing. Why do you think that might be? Well, for one reason, there's an unknown outcome when you put the decision of your case in the hands of the person who really knows the least about the student and knows the least about the school's offer and their programs. So of all of the decisions that get issued, this is a breakdown of what a typical year looks like at the Office of Administrative Hearings when decisions are issued. About 19% of all of the decisions are issued. The student wins on every single issue. About 37% of the cases that go all the way to a hearing decision, the school prevails on every single issue. And about 44%, or almost half of the cases, is a split decision. And that's because oftentimes there's multiple issues that are identified in a due process case. And there may be some issues where the school prevails and some issues where the parents prevail. And so it's pretty rare for either party to prevail on every single issue that they've identified in a hearing. So there's also a number of factors that go into analyzing whether to settle a case or to consider going forward to a hearing. First and foremost is the cost. It's very expensive to go forward to a due process hearing, especially when you have attorneys involved. And there's always the potential for unsuccessful litigation. So you could go forward and spend time and money and resources and time off of work if you're a parent, time out of the classroom if you're a teacher and an administrator. And there's always the potential that you won't prevail, no matter how strong of a case that you think that you might have. There also may be some procedural problems. So while a school may think that they are going to prevail on some of the issues about whether or not the student has made progress, There may be some procedural problems with meeting timelines or having the right people in attendance at an IEP meeting. And in those cases, a school could be found in violation of IDEA and remedies could be ordered. You also have to think about what's in the best interest of the child. Sometimes it may be in the best interest of the child to move forward to a due process hearing if the parties can't resolve the agreement. But in other cases, it may be in the best interest of the child to just resolve things so that everybody knows what the plan will be for the child moving forward. You also can't underestimate the stress and the emotional burden of engaging in a due process hearing. It can be very stressful in terms of having to be on the stand and having people question your integrity as an educator or the truthfulness of you as a parent. And so it certainly can be very taxing on both sides. Again, a settlement agreement can be a much more flexible way to resolve disagreements, and the parties control the outcome of the settlement agreement. So sometimes you may not get everything that you want, but oftentimes compromise is much more advantageous to both sides, which is why 97% of the time, parties resolve the case rather than going forward to a hearing. If you're looking for some additional information on these topics, you may want to check out the Center for Appropriate Dispute Resolution and Special Education, which there's a link here to that, and the Seeds of Partnership Alternative Dispute Resolution California Resource Hub, which also has a link here. Thank you so much.